Letters of administration. That is what we are looking at today. This applies when one dies intestate. Intestate is where somebody dies without a will. There are various sources of law that relate to this area. That's the Law of Succession Act and the Probate and Administration Rules. I'll not go through that now, but at least I've mentioned it to you so that in case you need to do your own further research, you know which part to look for. And if you click onto these links, it will direct you to the Law of Succession Act, and this other one will direct you straight to the Probate and Administration Rules. So I have put in here a flow chart which at least shows you how an grant gets given in the situation where you have somebody who has died intestate, and this is for your purposes, for you to know how it goes, and I will be discussing this throughout the entire presentation. So I'm going to start off with a death certificate, which is a self-explanatory thing. You will have to log on to eCitizen, and you will need an ID for a national identification card number for you to be able to do that. So log in there, find out how you can get a death certificate. This is the easier way to do it. Before it would take a long time, but now, you know, with technology, things are changing. And then the other thing that you have to worry about is the chief's letter. You have to go back to the place where the disease was living and contact the chief there. Some people are well known to the chief, but some are not. If the chief knows you, it may make it just a little bit easier for you. What the chief will be trying to ascertain, or rather the chief's letter just contains names of the beneficiaries and the assets that have been left behind. So for the chief to know who the beneficiaries are, you would have to bring their ID cards, and then you would have to bring, you know, evidence of the properties that the deceased owned, if it's a title deed or a letter of allotment or logbook, whatever it is that's there, you would have to bring it to the chief to be able to list it down. And then you would also need to have all the beneficiaries write down their consent. So they would be saying that we consent for person A and person B to become the petitioners and to be granted the letters of administration. It's as if you're saying we trust that these people can be given the letters of administration on our behalf. So in this scenario, it was a wife, it was a woman who lost her husband. So she was the petitioner together with her son. But the person who gave consent was the brother to the deceased, because her own other remaining son was underage at the time. And so once you have all those documents in place, you'll be ready now to go to your lawyer and file this petition in court. And I've put that petition here. I've put it here so that you can at least see what your lawyer will be filing. If you look at this one, it says, I, Joyce, and the other person, which is her son, we hereby petition this honorable court for a grant of letters of administration for the estate of the above named person who died domiciled in Kenya on this and this day. So I'm presenting this petition in my capacity as a wife and as a son of the deceased, and every person having an equal or prior right to grant of representation herein has consented. You see, so you're saying that I am coming to petition. I'm petitioning as a wife together with my son, and every other person who is a beneficiary has consented to that being the case. That is why you need the consent document. And now this has to be accompanied by an affidavit. The petitioner would sign the affidavit, and pretty much she's just confirming that she is the wife, that the deceased was her husband, he died on this day, and he left the following people behind, and these are also the assets that he left behind. You can see they're listed right there. It's a couple of properties, shares, and the motor vehicles and bank accounts. And make sure you list everything in here, because say, for example, there was another account. In here, she's listed an account in Equity Bank on Digo Road in Mombasa. But if there was 3 other accounts that are not listed here, it might prove to be a problem when trying to get money out of that bank. So after that, you would also need another affidavit from still from the petitioners, where she would be justifying herself to become a proposed administrator. So in this one, she's saying that I, Joyce, having petitioned this honorable court for a grant of letters of administration intestate of the estate of the above named this and this person. So she's saying that she's making an oath and saying that I am, after payments of all my just debts and having taken into account all my liabilities, well and truly worth the net of such debts and liabilities in immovable and movable assets in Kenya, at least the sum of. So she would be saying I am worth this amount, you know. So it's like she's saying I am not bankrupt. I can do this job. You can trust me with this. And then she would also need sureties. In this case, she had two sureties, and they are also saying the same thing, that look, we are worth, one of them is saying I am worth 4 million, the other one is saying I am worth 2 million, and so I will stand in as a surety. I'm not bankrupt. I got this. That's how they say it in America, but of course we are in Kenya and we'll talk even with our Kenyan accent. So then you also need guarantees by the personal sureties. And the sureties are people who give a guarantee that to the court that that the administrator will perform their duty. And if they do not, if the administrators do not do so, the sureties will compensate any financial loss suffered. So the sureties you get, you must be sure that at least they have the ability to do that. And if you're being asked to be a surety, you must understand that that's the liability that will fall on you if the administrator doesn't come through. So once you file this in court, you then will have your notices drafted. What are the notices for? You see, this process has only gone on between the families, so nobody else knows that the court that the administrators have petitioned the court. But this must be made public because we're dealing with an estate of a deceased person. It must be made public, and these are the notices that are drafted. And if you look at the first notice, in fact, we can read it. It says, let all persons concerned take notice that a petition for a grant of letters of administration intestate has been filed. That's what you're saying. It has been filed at this registry, and it has been filed by this person in the capacity of our wife. And then what do you do with this notice? You take it for gazettement. Gazettement in the Kenya Gazette. So this is not just the daily newspapers, it's the Kenya Gazette. And so it will be printed there, and you have to wait for 30 days before a temporary grant can be issued. That is if there's no objection. But the question is, why would there be an objection? Why would anybody object to a petition like this? So, I mean, in our society, especially a polygamous society, you come across men, for example, who have many wives. And if one wife does this petition and omits to say that the man had other wives, other children, or if she puts some properties but not all the properties, then that in itself is a problem. So you would raise an objection if you're the wife who has been omitted, or if you're a child who has been omitted. You would raise an objection and say, you know what, I need to be included in this thing. And this part of the process could take a while. Like, to give you an example, the Mbiu Koinange case, we all know Mr. Koinange. He died in 1981. It's only until around the year 2018 or 19 that his estate was finally settled. After all those years, they fought and fought and fought between wives and between children. It was at this stage for a long, long time. But if there's no objection, then that makes it easier, because this is the grant that you will get right here. You see, if you read it, it says, be it known that on the 3rd day of this 2017, letters of administration intestate of all the estate of this and this person who died here and here were granted by this court to Joyce. So she gets it. But she also has to wait 6 months. And 6 months later, she then goes back to court for them to confirm that grant. And for it to be confirmed, she needs to apply. It's called summons for confirmation of grant. So your lawyer will still have to do this process for you. And it's a simple application. You can see it, here it says, they're asking for orders that the grant of letters of administration intestate which are made to so and so be confirmed. It's a really straightforward situation. And then this is what you get in the end. You get a a certificate of confirmation of grant. And that's it. You're done.